This begins Chapter 5. Chapter 5 is concerning civil rights, and as we will see, it is an evolution over time. This is part 1 of Chapter 5. There will be 5 parts to Chapter 5, as you will see. The videos and the PowerPoints are equally broken out. Madison, in his Federalist Papers number 10, talked about extending the sphere of the Republic and to take a greater variety of parties and interests. You make it less probable that the majority of the whole will have a common motive to invade the rights of other citizens. What he was talking about in this particular case has to do with collective action. That as the diversity of the group is expanded, the ability for collective action by a single majority becomes much more difficult. The end result is that there has to be then the different groups coming together to resolve the differences that they have to reach some type of agreement. This is an important concept of collective action, and as you will see, relates very clearly to this process of civil rights. Thus, as I've already stated, that collective action is much more difficult as the number of individuals as well as the diversity of the individuals increases as well. As you notice, civil rights attempts to shape collective action by regulating who can participate in the process and how they can participate. But it does involve more than just politics, as we will see. A key portion of this evolution of civil rights has to do with the 14th Amendment, which was part of several different amendments that were passed in and around the Civil War period time. The 14th Amendment holds that no state can make or enforce any law that shall deny to any person within its jurisdiction equal protection. And as I've mentioned, I believe that this provides for equal protection of the person rather than the citizen. As Madison correctly identified, as protection of minority rights were sometimes found to be insufficient, history has proven that the potency of the 14th Amendment's explicit constitutional guarantee for expanding civil rights in America have come to fruition. In 1982, and there will be other cases that we will see later on, but in 1982, in Plyler versus Doe, the Supreme Court invalidated a Texas statute that sought to deny public education benefits to illegal immigrants. The ruling, however, was a 5-4 decision, and the ideological balance, of course, of the courts have changed, a key issue in this upcoming election. We will see, for instance, what the ruling or a similar case might look like in the future. So as we've indicated, civil rights is much about who, what, and how much. It attempts to answer 3 questions. Who has the right and who doesn't? A right to what, as you can see here, and how much can they exercise that right? As it indicates, the answers, of course, have changed over time. An excellent example is this, that non-citizen inhabitants and African American inhabitants of the state of New York were allowed to vote from 1777 until the revision of the state constitution was adopted in 1821, which at that time denied voting rights to these groups. While generally the flow of history has expanded civil rights, there have been some significant and dramatic steps backwards, as indicated by the situation in New York. The right to vote, of course, is not included in the Constitution, and initially states restricted voting based on a variety of issues. In a Supreme Court case, Shelby County versus Holder, of which the state of South Carolina was a party of, the court struck down the part of the Voting Rights Act of 1865 that related to pre-clearance of changes of law that affected voting rights. Prior to this case, the Department of Justice was responsible for reviewing states and their laws concerning voting and voting processes. With the case being of Shelby versus Holder striking down this pre-clearance issue, this has now provided the states more freedom to change their voting laws as they see fit. This concludes part 1 of chapter 5. As you can see that the issue of civil rights will cover a variety of issues and is rather involved.